welcome to Ipsa Dixit, a podcast on legal scholarship. I'm your host, Brian L. Fry, Spears Gilbert Associate Professor of Law at the University of Kentucky College of Law. My guest is Shubha Ghosh, Crandall Melvin Professor of Law at Syracuse University College of Law. We will discuss the book he is editing for Edward Elgar on forgotten intellectual property law, as well as his own contribution to the volume, If Music Did Not Pay, the State Court Roots of Justice Holmes's Intellectual Property Jurisprudence. So welcome to the program, Shubha.
Yeah, thanks. It's an honor to be on. I've been listening for a while, and it's been great. So I hope I can carry on the mantle.
No, I'm delighted to have you on. As you know, I've admired your work and your indefatigable sort of presence in the intellectual property community for a long time. And I was wondering, just as a way of kind of framing today's episode, if you could talk a little bit about the concept of the book that you're editing. Like, what kinds of articles will it include, and what's the sort of origin of the book project?
Sure. Well, the book, as you mentioned, is about forgotten intellectual property lore, and it originated from a symposium that occurred at the Syracuse Law Review published in 2018 on forgotten intellectual property cases. And so, going back to, 4 years ago, I think there was an exchange on Facebook, and you may have been part of that. I know Zvi Rosen at GW was part of that, and I think he's sort of the inspiration for the Forgotten Intellectual Property Cases Symposium. I think he was doing some research at the Library of Congress and came across a case that's pre-Baker versus Selden that people really hadn't talked about that often, which is the Paris versus Hexamer case. And actually, I had just read that case coincidentally for something I was doing on copyright and maps, and it's an interesting early case about copyrightability of maps. But anyway, as happens on Facebook, and especially among real people, not bots, the conversation turned interesting about what other cases have just been forgotten. And so that was the inspiration for the symposium. We sent out a call for papers, got about 7 or 8 contributions. Basically, the call asked for somebody to identify a case that they thought had been sort of forgotten in the IP canon, and to basically write an article explaining why the case is important, why they thought it might have been forgotten, and the issues about reviving it and maybe making it part of an expanded canon or an alternative canon, and how we think about it. So the Forgotten IP Cases Symposium, I'm pretty proud of it. I'll read off the list of contributors, just alphabetically. Robert Browneye, Samuel Ernst, Amelia Smith Reinhardt, Jessica Kaiser, Bruce Boyden, and Brian Fry and Zvi Rosen. And these are just a great set of papers. Your contribution, Brian, as I think hopefully the audience knows, is about patent rights of slaves, so Invention of a Slave, great title. We had Zvi's paper on Paris versus Hexamer, Jessica's paper on trademarks in the wallpaper case and how they intersect with competition law issues. Amelia Reinhardt's paper on the Beeman and Sons versus National Harrow Company case about the early patent antitrust interface, and there are others. I won't go into all of them in detail, except look up the symposium. I think you'll find these papers very interesting. So after this came out in 2018, the idea was to try to expand it into a book and to expand it beyond just simply looking at forgotten cases, hence the title Forgotten Intellectual Property Lore. And the idea of looking at lore is to include not just simply cases, but also disputes that may have not gone to court, legislation that may have been abandoned, legal conflicts, if you will, for lack of a better term. regarding intellectual property. And so we have about, I'm in the process of editing. We have about 14 papers now, including, again, Brian, your excellent contribution on a copyright dispute from Ireland in the 6th century. We've got several contributions about intellectual property disputes after World War One and World War Two, and then my piece on Justice Holmes' state law jurisprudence. And I think the idea behind the book is, first of all, go beyond the U.S. The forgotten IP cases largely focused on cases in the United States, and so we have interesting contributions from India, from scholars in Africa. As I mentioned, your piece on Ireland. We've got disputes. Robert Spoo's paper about James Joyce's poems and how they were published in the U.S. outside of the copyright regime. So, and I think there's a really interesting bunch of papers, and I'm not, giving justice to all the contributors, but hopefully we'll be able to explore and do a deeper dive as we converse.
Yeah, I mean, I have to agree that I think that the Forgotten IP paper, the Forgotten IP conference was one of the best conferences that I've attended, and the work really was great. And I've done interviews with several of the contributors to that conference already. And I gotta say that the book looks like a wonderful sort of expansion on that same project, which I think will be um, I think will spark a lot of interest in kind of thinking about sort of intellectual property in a broader sense. And I think it's a nice contribution to the current interest in sort of the sort of IP without IP, or kind of thinking outside the borders of cases sort of scholarship.
Yeah, no, I think that's right, and I think I've always been intrigued by the idea of a canon, whether in intellectual property or in life, as they say. But and so I hope these would be good materials for future scholars as well as to integrate into the classroom, because I think this is something that students can contribute to in terms of their research work while in law school, and not just simply in law schools. In other departments where there's a focus on issues about creativity, commercialization, culture, technology diffusion, all of these types of broad questions.
Yeah, and I think it offers a lot of kind of cross disciplinary opportunities as well. And I've noticed lately, doing the podcast and talking to friends of mine in the humanities and social sciences, other than law, the extent to which kind of these kind of crossover conversations can be really productive in thinking about how, you know, other disciplines inform legal scholarship, and legal scholarship can offer something to people in other disciplines as well.
Yeah, exactly.
I mean, as an example of the kinds of articles that'll be in the book, I mean, I wonder if we could talk a little bit about your contribution, which I thought was fascinating because I've always found Justice Holmes, I mean, like so many other people, a really sort of, in some ways, iconic, but also sort of enigmatic figure in
Yeah.
American law. And your
Mhm.
paper kind of focuses on a lesser known, lesser studied period in his career. So, you know, for listeners who aren't that as familiar with Justice Holmes's sort of career trajectory, as it were, I wonder if you could talk a little bit about his sort of life story, with a sort of putting a pin in the period that you're most interested in.
Well, the paper looks largely at his time on the Massachusetts Supreme Court, which is from 1882 to 1902. And in 1902 is when he was appointed to the United States Supreme Court by President Roosevelt. I mean, I should give the usual caveat that I'm not a Holmes scholar. There's so much Holmes scholarship out there, so I want to, kind of apologize in advance for major gaffes in my accounting here. But I'm looking at the period when he's on the Massachusetts Supreme Court. As I understand the history, he had been appointed to an academic position at Harvard Law School, which I think he only lasted a couple of months, not because of lack of capacity or ability by any means, or any kind of academic politics. I think the politics of any here was he wanted to be a judge, and so he gave up his position at Harvard Law School. And I think there was a lot of controversy about him doing that at the time. I don't know if he breached. Maybe it's an early example of his efficient breach of contract or something with the law school. But he was on the Massachusetts Supreme Court from 1882 to 1902. I think he was a chief judge at the Massachusetts court the last year or so. And so my thought, I forgot how I even got into this. I mean, frankly, I had this paper floating around for the last 10 years or so, and I really hadn't done much with it. I'd given some presentations about it. I actually even went down to the Historical Society in Boston and did some archival research, and then spent a lot of time reading the secondary sources on Justice Holmes, as well as looking into his published opinions while on the Massachusetts Supreme Court. I think the way I got into this was partly because, as you suggested, Holmes is an iconic figure. Had written obviously, some very seminal intellectual property cases while he was a Supreme Court justice that are part of the canon. And so I was curious about that influence that he had in the field, as well as noticing that, especially high courts in India in certain IP cases had been citing Holmes, as I suggest in the paper, for no other reason other than some sort of rhetorical flourish or legitimacy, whatever may be going on. So that was definitely something that was intriguing to me about that. As well as I think at the time, about 10 years ago, I was doing some work on IP and contract, and I'm still very much interested in the relationship between state and federal law in the realm of intellectual property. So then, I guess some light bulb moment, I realized, well, I mean, Justice Holmes was on the state Supreme Court, and then he goes on to the federal bench and writes these famous IP cases. What had he done while on the Massachusetts Supreme Court? I mean, I was aware of the Waltham Watch case before I started doing my case digging, but then I found that there were, several cases while he was on the Massachusetts Supreme Court where he wrote the majority opinion. There are other IP cases that did come up in the Massachusetts Supreme Court that he signed on to, but for this chapter, I only focused on the opinions where he was authoring the majority opinion, so decisions where he's authoring the majority opinion. And so there were about, 35 of those, or excuse me, 22 of those while he was on the 20-year period on the Massachusetts Supreme Court. So um, I basically focus on those opinions. I try to put them in a broader context of what was going on during his time in the Massachusetts Supreme Court. But I offer the thesis that some of the things he was doing on the while on the Supreme Court, the U.S. Supreme Court, you can trace it back to his experience as a state court judge dealing with intellectual property cases. And um, it is unusual to see intellectual property at the state level, of course, since a lot of it is federal law. But we'd expect to see trade secret and probably trademark cases in state Supreme Court decisions on occasion. There weren't any trade secret cases that Justice Holmes authored while on the Massachusetts Supreme Court, though there were several when he was on the federal bench. There were quite a few trademark cases as well that he authored while on the Massachusetts Supreme Court. But I was surprised by the number of patent cases, and these aren't actual patent infringement cases, of course, because those would arise in exclusive jurisdiction in federal court. But they largely involved commercial issues that involve patents. So disputes over contract disputes over patents, fraud claims involving patents, some state unfair competition, and antitrust issues involving patents, and some issues of patents in wills and trusts as well. So that was kind of fascinating to see what he had been writing on that, especially given some of the work I was doing on IP federalism, and that continues to interest me. And so, um, I can elaborate more on the thesis, and I hope we have a time to do so. But I kind of the point of the chapter is to suggest that this is an aspect of IP lore that has been forgotten. But I think the point of unforgetting it is to see how it may have shaped sort of the commercial and business perceptions. I think that Justice Holmes had about intellectual property when he was writing his Supreme Court opinions.
Yeah, so I mean, this is one aspect of the paper I found really fascinating, because we think about Holmes in kind of his academic capacity as being a real systematizer, and yet you describe his state court opinions as being kind of much more kind of functional and practical in some ways, and then suggest that that perhaps informed his ultimate kind of approach to being a Supreme Court justice. And I feel like in a way it's like it seems as if you're almost suggesting that the like that period on the Massachusetts Supreme Court informed his sort of worldview in a way that maybe we don't fully appreciate as deeply as we ought to.
Yeah, and there's a citation very early on to Mark Tushnet's, Professor Tushnet's article in the Virginia Law Review in 1977. So that's been out. Obviously, it's a one of the important pieces of secondary scholarship on Justice Holmes that does talk about his time on the Massachusetts Supreme Court. And hope I can do Professor Tushnet's thesis justice. But as I understand his thesis in the Virginia Law Review article, that really his time as as a judge in the state Supreme Court largely was about experience. That he was kind of eschewing, in some ways, these kind of grand theories and really trying to, rolling up his sleeves, so to speak, and getting into the work of being a judge. And so Professor Tushnet ties it into, I think, quite interestingly, into the whole tension between logic and experience that comes up in a lot of Justice Holmes' writing, and that I also touch upon, and especially when he gets into the free speech jurisprudence that he developed while on the U.S. Supreme Court. So I think that's the sense I get. I mean, I think part of it is he was leaving academia to do this judgeship. So yes, he is a systematizer. I mean, I guess he's a high modernist, whatever the right label might be. He had left academia to go to the bench, and so we do view him as a sort of a systematizer, maybe not a doctrinalist in the Germanic sense of how traditional legal academia is viewed in Germany, kind of just creating a system. But certainly, we sort of appeal to Justice Holmes in that way on occasion, as maybe establishing a canon. But certainly, probably the best way I would characterize Justice Holmes is sort of a high modernist. You know, throw out tradition, and this is what's going to take its place. But at the same time, he is very much embedded in the practice of law.
Do you see a tension between sort of Holmes, the professor, publishing the common law, this sort of magisterial text on the sort of theoretical history of the common law, and Holmes, the judge, like having to put this stuff into practice and being like realizing that, those weren't the same thing?
Yeah, no, I think that's right. I mean, I think in the paper I quote, in my paper I quote this letter that he wrote to Felix Frankfurt in 1913, where he describes academia as but half a life. I mean, I'll read the quote a little bit. It is withdrawal from the fight in order to utter smart things that cost you nothing except the thinking them from the cloister. A business in the world is unhappy, often seems mean, and always challenges your power to idealize the brute fact. But it hardens the fiber, and I think is more likely to make more of a man of one who turns it into success. And I think there's a lot going on there, not just simply kind of academia versus the world of commerce and the world of business. Justice Holmes is, on the one hand, strongly a man of experience. He fought in the Civil War. In some ways, he was, I don't know if reacting is the right word, but he was certainly in the shadow of his father, who is a, established doctor and poet, sort of a literary figure as well as a person of science. And, Justice Holmes was largely in the world of law, of course. And so I think experience guided his perception and the way in which he viewed the law, probably more than kind of the formal rules and structures that we sort of attribute to him.
So, well, among other, I mean, I want to return to talking about the relationship between Holmes and his father, which you talk about in your paper as well. But just briefly, I mean, I wonder if you could reflect on whether sort of seeing intellectual property issues like trademark and patent law issues through the lens of commercial law and commercial practice might have inflected Holmes's perspective on sort of what intellectual property was for and how to understand intellectual property theoretically.
Yeah, I think it did. I mean, so it's interesting at the end of the day, at the end of my writing this chapter and rethinking this chapter and rereading it, what exactly we get out of Holmes. But I do think he ends up viewing intellectual property and the subject matter of intellectual property as what we might think about as ordinary commodities. I mean, the title of the chapter of music did not pay is from the Shaney case having to do with public performance rights, and specifically that's the facts of the case having to do with playing music in a restaurant. And the language in that opinion is kind of striking. The way he kind of contrasts and compares, and almost at some point uh, puts at the same level the kind of things that the restaurant serves up, not just simply the food and the atmosphere, but also the music. And the Blystein case, this one that has gotten a lot more attention. I think it's probably a case that that's probably taught in every intellectual property course. Um, I think it's largely about the, the role of the marketplace in determining culture, and the language in that opinion that's often cited about how judges are not in a position to make these aesthetic decisions is also a deference to the marketplace and viewing copyrights, so to speak, as just ordinary commodities that are bought and sold like anything else. Now he did not write any copyright opinions in the while on the Massachusetts Supreme Court. So one counter to my thesis is it might be a leap to go from what I'm seeing in the Massachusetts Supreme Court to his copyright opinions while on the U.S. Supreme Court. But at the same time, if you look at the language he uses in his copyright opinions, they all are about kind of business and commerce and the language of the marketplace, and really do parallel the things he was saying about trademarks and patents, especially patents, remember, which is federal subject matter, while on the Massachusetts bench. So I think that's the sense I get of Justice Holmes's IP jurisprudence, writ large. Um, I'm trying to think about some of the chestnuts and some of the conclusions or um, conventional opinion about Justice Holmes and IP. I think a lot of it is this kind of high modernism that IP has these particular goals. Uh, they may be grounded in some notion of the facts of creativity. I mean, Justice Holmes is probably less deferential in some ways to Congress than, for example, Justice Harlan. I mean, Justice Harlan's dissent in Blystein, if I remember correctly, is largely let's just follow what Congress said, and these posters would not be copyrightable based upon the statute. So it's more of a kind of that's even sort of a more contemporary, i.e., 2019 view of intellectual property. It's sort of congressional legislation. Justice Holmes, I think, had a realistic notion in the sense that he wanted to ground IP in the facts of what he saw around him, rather than necessarily on some big theory of IP.
And in a lot of ways, I mean, it struck me that it seemed like Justice Holmes was viewing intellectual property primarily through the lens of competition policy rather than kind of a broader social policy about what we might want to achieve through these kinds of regulatory arrangements. In other words, kind of just deferring to the marketplace.
That may be the case. I think certainly. I mean, I think I would go a little bit stronger and say I don't know if he really had a sense of policy. I mean, that's this is one of the things where Justice Holmes is so annoying in some ways because he talks when he talks about, on the one hand, he talks about general principles, but then he also talks about general principles being kind of I don't know if he uses the word hogwash, but I could picture Justice Holmes saying that about general principles. And so he wants to go back to facts, facts in the world, even though he also understands that facts by themselves may not tell us much. The kind of the problem of going from an is to an ought, or from the problem of just simply talking about the phenomenon of IP without necessarily having a broader sense of what IP is supposed to do. But I would characterize Justice Holmes here as kind of a realist. IP is there. People will do with it what we will, and the role of the judge is to sort of accommodate that the best possible. So it's not a realist in the sense of Congress enacted these laws. We can either defer to Congress because Congress is the legislative branch and the judges are just simply there to interpret. But think about what's going on in a case like Eldred, right? Just Congress has spoken, and therefore the courts need to follow. And so he's certainly not a realist in that sense, and he's also not a realist in the sense of, yes, Congress has is talking, but it's really industry that's speaking, and therefore we need to look at these Congress's pronouncements very closely and scrutinize them to death, and occasionally reverse them and do the opposite of what Congress is saying we should do in the statute. I think he definitely was a realist in the sense of we think about this in the context of pragmatism, and I think Justice Holmes had a weird version of pragmatism, which we could explore. But I think I like the word phenomenological. I mean, that's kind of a word that's a $5 word for maybe a 50-cent problem in some ways. But I mean, I think he observed this stuff that was around him, and he judged accordingly.
Mm. Well, I mean, so maybe that's a nice moment to turn to the relationship between Justice Holmes and Dr. Holmes, right? And I,
Yeah,
I really like the kind of comparison you made where, Justice Holmes' father, Dr. Holmes, Oliver Wendell Holmes Sr., kind of talked about the play of ideas, whereas
yeah,
Justice Oliver Wendell Holmes Jr. is better known for this idea of the marketplace of
right,
ideas. And I wonder if you could talk a little bit about what you kind of think the difference between those two is, and how it
right.
informed their respective worldviews.
Yeah, and so I don't know if you have can you accommodate footnotes in your these well, so the footnote here, if this were written, would be to Peter Gabian. Let me sure I get the name right. Peter Gibbion's chapter in Robert Gordon's collected essays of Oliver Wendell Holmes, where Professor Gibeon goes into the relationship between father and son. So I do draw on that, but I go a little bit beyond that, I think, and I hope I'm not stretching it. I mean, I think it is really interesting to compare and contrast father and son. And I've always, I haven't read Oliver Wendell Holmes Sr. since I think junior high. And I'll talk a little bit about how I went back and prepared for this podcast by looking back at Oliver Wendell Holmes Sr. But drawing on the Gibeon book chapter, I mean, there's the points you made about contrasting versions of the marketplace of ideas or free speech. The father seemed to think about this as a as play, as exchange. That free speech is about kind of this exchange of ideas. It's kind of like what we're doing now. Um, Justice Holmes seems to view it like the old McLaughlin group or something, which fortunately is not the tone of your podcast, Brian. So if you remember the old McLaughlin group, it's just people shouting at each other. It's kind of like the House of Commons, in UK Parliament. It's a battlefield, and so Justice Holmes is excuse me, Dr. Holmes, Oliver Wendell Holmes Sr. had sort of a more playful, kind of a sweetness and light version, sort of a civilized version of uh, the marketplace of ideas, if you will, while Justice Holmes had more of a kind of a battlefield. It's somebody's going to win, somebody's going to lose, and so that's something that Gibeon plays with. I don't think of exaggerated that too much, but I think that's a really interesting contrast. And there are other contrasts too, obviously. Holmes Sr. was a doctor and a poet. As a medical doctor, he maybe had a more balanced view about how far medicine could go to alleviate the sick, to cure disease, and it was tempered by this kind of a humanist notion through his writings. And Justice Holmes, maybe it's kind of more of a hard and fast lawyer. I mean, he wasn't a litigator, Justice Holmes, but he was aware of the law as a battlefield. I mean, to go back to that metaphor, and that maybe very contrasting notions of what the profession is, and the professional background of father and son. But I want to also talk about maybe ways in which there's some interesting similarities. And here I am kind of talking a bit off the top of my head. But I do remember way back in junior high, we read, I think it's probably the only thing, or at least the last thing I remember ever reading about by Oliver Wendell Holmes Sr., which is the poem One Hoss Shay, which I don't know if they still read in junior high, or if anybody's read. It's kind of an interesting poem. And so, in preparation for this podcast, I went back and did some research. I read the poem. I actually, on YouTube, I found an audio of Eddie Albert. Remember Eddie Albert
No.
reciting One House Shay.
Huh.
And remember Eddie Albert. I mean, the double irony here, of course, is that Eddie Albert played a lawyer in Green Acres named Oliver Wendell Douglas. So I don't know. There's all sorts of weird pop cultural connections here. But the One Hoss Shay is a really interesting poem. I think in part it was a criticism of Calvinist thought, authored by the father. It basically is a description of the one horse shay as a type of carriage, and it's the poem discusses the logic, and he does use the word logic in the poem a lot, on which the one horse shay was constructed. And basically, the poem is about how that logic has fallen apart over time. And so, in that poem, it's interesting to read that poem in light of Justice Holmes, Holmes the son, who also has this tension, as we've talked about, between logic and experience. And the one Hache, among the many things that are going on there, is this kind of move to create these kind of rational, logical systems, and how they give way to the real world, how they give way to history, how they give way to just change. And certainly, that's something that you see in Justice Holmes's thought. This tension between experience and logic. It's just that the balance, I think, that the father and son find is very different. I mean, Holmes the father, as I suggested, the series of essays that he wrote was The Autocrat at the Breakfast Table, which is the whole appeal to autocracy. At the one hand is interesting, but but placing the autocrat at the breakfast table is kind of an interesting, ironic twist because there's a domestic quality to it. Obviously, that it's. I don't think he means autocrat in terms of a strong father figure that dominates. It's more of a conversation, more of a. It's a very domestic view that Holmes, the father, had. While going back to the Gibeon book chapter, Holmes, the son, seemed to view this notion of logic and experience, exchange, if you will, in terms of war. I mean, he really was thinking about his experiences in the Civil War and probably how he may have perceived the legal system operating as well.
Well, so Shubha, in closing, I mean, I wonder if you could reflect on, given the extent to which Holmes's perspective on intellectual property, I think, has in a lot of ways informed this sort of current state of intellectual property doctrine in sort of
Yeah.
some deep formal senses. I mean, I wonder if you think that this perspective that you're bringing offers any sort of corrective perspective or kind of ways of reconsidering the sense in which a kind of Holmesian perspective has structured the way that we conceptualize the nature of intellectual property ownership today.
Yeah, I'm definitely keen on the realist perspective. I don't know if I view reality in the same way that Justice Holmes does, but I think there are two notions that I want to emphasize here. One is the idea that I presented a few minutes ago about the marketplace. I think we really need to think about, for example, if we think about the marketplace of ideas as it plays out in the intersection between the First Amendment and intellectual property, whether it's in copyright, patent, trademark, whatever the micro regimes would be. What exactly is our perception of that marketplace? What exactly are we thinking about as exchange? And how does the exchange of ideas, the exchange of information map onto market type exchanges? I mean, it's not a perfect fit, even though some people want to make it a perfect fit by reducing information into a priceable, transferable, alienable commodity. And so I think that's something that Holmes could have been more reflective about. But if you go back and look at what Holmes was doing, he was basically trying to have a particular view of the marketplace that's worth uh, acknowledging, but also worth taking apart critically. And I think, especially in his trademark cases and his patent cases, where this IP realism um, plays out, is also into some sort of a social constructivism. What exactly does that mean? I think the whole idea of constructivism is sort of overused in the sense of also not being perfectly understood. But I think Holmes was attuned to history. Holmes was attuned to practice. He had a particular perspective on it. But I think the kind of empiricism, the kind of appeal to experience that Holmes had is worth building upon, but going beyond what Holmes actually did with his narrow sense of experience. So those are the two lessons. One might be more of a conceptual, what is the marketplace that we're talking about? What do we want it to be? And then secondly, really focusing on experience and facts in trying to understand IP policy and IP doctrine.
Well, thank you so much, Shubha. I mean, I really enjoyed talking to you about your paper, and I am super looking forward to seeing the book and reading all of the rest of the essays that are in it.
Yeah, thank you for taking the time, Brian. I enjoyed being able to try to articulate what the chapter is about, and I'm excited about your book chapter as well. I think it's going to be exciting, as well as the other contributions. So, coming to a book stand soon, I hope.
'86. on the occasion of receiving the degree of Doctor of Laws from Yale University, Justice Holmes spoke of the power of honor to bind men's lives. He said, "If it does not lift a man on wings to the sky, at least it carries him above the earth and teaches him those high and secret pathways across the branches of the forest, the travelers on which are only less than winged. You maintain the honor you have bestowed." And how marvelously he has done so through the nearly 50 years which have passed since then. Justice Holmes will now speak to you from Washington, D.C.
In this symposium, my part is only to sit in silence. To express one's feelings as the end draws near is too intimate a task. But I may mention one thought that comes to me as a listener in. The riders in a race do not stop short when they reach the goal. There is a little finishing canter before coming to a kind voice of friends and to say to oneself, the work is done. But just as one says that, the answer comes, the race is over, but the work never is done while the power to work remains. The canter that brings you to a standstill need not be only coming to rest. It cannot be while you still live, for to live is to function. That is all there is in living. And so I end with a line from a Latin poet who uttered the message more than 1,500 years ago. Death, death plucks my ear and says, live, I am coming.
Thank you, Mr. Justice. We now return you to the New York studios.
Ladies and gentlemen, we have just presented a program in honor of Mr. Justice Oliver Wendell Holmes, were Justice Oliver Wendell Holmes, whom you have just heard, Justice Charles Evans Hughes, Dr. Clark, Dean of the Yale Law School, and Mr. Boston, President of the American Bar Association.